support the application I'm making. I have two factual matters to bring to your attention. For the sixth respondent in E646 of 2025, that is Mr. Abraham Robert Guyo. Mr. Guyo has an appointment to see his doctors. He is in a very critical condition that will be seeking that after we finish the hearing, he be allowed to go and get attention of his doctor. Your Honor, I wish to bring to the attention of the court and to take judicial notice that in a matter we were with Mr. Ndubi and the other counsels before the High Court, where the former town clerk requested the court to allow him to go to hospital. And the court declined. We proceeded, and the next day we reported to the court that John Gakuo passed on. And from that, Mr. Guyo needs to see his personal doctor. The police can escort him to see. We wouldn't want that repeat. It haunts me every day. I remember that plea. For E648, for the second respondent, Judy Kemuntondari, she is a proud mother. She brought another young Omari to the world on the 3rd of October, 2025. She undergone serious medical cesarean section with a preterm child. That child is important.
On what date? The date?
She gave birth. The child is here, I think. The child is around a few days. Preterm. The court wants to see the child. It's not you to see the child.
Yes.
She's supposed to,
The date of the C-section.
the cesarean was 3rd November 2024. I've given the medical sheets to the court. The child is breastfeeding, Your Honor, in the best interest of the minor. I make the following application that that mother, kindly the court, do enter her into bond terms and bail terms to allow for this child. The police are very good friends of mine, only when they are arrested. But when they arrest, we can't allow the mother to breastfeed. And Mr. Kamau should advise the police to be human. It's about this child, not about the accused. Much obliged. You know, I hereby make an application for all the people that we are representing for bail and bond. One, that no compelling reasons have been provided to deny them bail. In the celebrated case of Duit Sagaran and 3 others, you know, I'm talking about criminal case number 61 of 2012, where Justice Koril put it clearly that if the state wants to rely on evidence that those people are likely to interfere with witnesses, material evidence must be presented attached to an affidavit. That decision has not been appealed by the state, and before you, there is no material evidence presented in line of this High Court authority. I've given the state the authority. The court is aware of that authority of Duat Sagari. This was a foreigner, a Venezuelan foreigner, released on cash bail. Our Kenyans who are here deserve better than that. If we release foreigners on cash bail, then our foreigners, our Kenyan citizens need a better issue than that. You know, the second authority is the Criminal Revision number 208 of 2020. Criminal Revision number 208 of 2020, Sudi Oscar Kipchumba versus the Republic. When this matter appeared before then Justice Professor Ngugi, sitting in Nakuru, now he's a Court of Appeal, the judge in paragraph 24 set out this: whenever the state wants to apply for miscellaneous application to detain anybody under Article 49(1)(f), the court must look at two tests. Before, the court must look at the two tests. First test, the court must be persuaded that the state is acting in absolute faith, and that the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances. The respondents here have been investigated for a long time by a multi-agency team. They have been tracked. They were trailed. And that is why everybody was picked from their houses. It is not an offense like terrorism that happens suddenly and people must be arrested and be brought to court. Two, on the DCI Twitter handle, the faces of these citizens has been splashed all over. Some of their relatives who are fathers-in-laws, mothers-in-laws, and their children have seen these people. Today in the morning, I urge the court to take judicial notice that there were others, like these ones, who the state today came and said, sorry, we got wrong people. Release them to go. That damage. That is somebody's husband. That is somebody's wife. That is somebody's daughter. Good faith, the first test, the state fails. The second one, the judge said, the state must demonstrate that the continued detention of the individual without a charge is the least restrictive action it can take in balancing the quadruple interest present in a potential criminal trial: the rights of the arrested individual, the public interest, order and security, the need to preserve the integrity of the administration of justice and the interest of victims of crime where appropriate. By virtue of Article 21(1) and Article 259 of the Constitution, the court must act to aggrandize, not diminish, the personal liberties of arrested individuals in line with other free interests. Differently put it, the state must demonstrate that there are compelling reasons to deny pre-charge bail while balancing all factors within the complex permutation presented by these quadruple interests. We have argued over this matter with my brother before you every other time. Is detention the least intrusive? Can they be allowed to go home? They report every day to the police investigating officer. Your Honor, the judge is trying to say, let us not congest police stations and let us not congest remand homes when there is nobody who is being charged. Your Honor, lastly, the judge went ahead in paragraph 32, having reached here in my analysis, the result appears eminently tautological. The application herein largely succeeds. There are no compelling reasons for the continued pre-charge detention of the applicant. All the concerns raised by the state can be accommodated without the very radical measures sought and granted to the state to hold the applicant's pre-charge for 11 days. In the circumstances, he released Oscar Sudi on bail. Your Honor, that is now a Court of Appeal judge with that position, then as a judge. Your Honor, this question was also put across in Machakos in criminal case number E007 of 2024, Republic versus Boniface Juma Yeko, Geoffrey Okoth Okeyo, Tony Omondi Omolo. The court is aware of these authorities. The court in paragraph 25 and 26 said, in my view, therefore, the prosecution has not provided any substantial evidence to support its submissions. I find that the reasons cited do not meet the threshold established under Article 49(1)(h) of the Constitution. The suspects were released on a cash bail and they went home. The last authority, Your Honor, is the authority of the Court of Appeal. The Court of Appeal, which binds the High Court and binds this court, in the celebrated case of Michael Juma Oyamo and Caspal Ojuang Obiero, criminal appeal number 113 of 2018, the three judges, Justice Wasame, the President of the Court of Appeal, Justice D.K. Musinga, and the late Justice Professor Otieno Dek, made it very, very, very clear in paragraph 34, 35. In this authority, Your Honor, the judges are saying the court should give conditions. And I'm appealing the court to release them on bond and impose conditions. A few facts for the benefit of the state in that matter. The governor, Obado of Migori, then was released in the High Court by virtue of carrying power. His driver and bodyguard were denied bail because they were small people. They went to the Court of Appeal, and the Court of Appeal ordered they be released to enjoy the benefits. You know, these are clerks. Some are messengers. Some are very junior immigration officers. Some are very junior registration officers of the National Registration Bureau. Release them on bail as the matter for the Court of Appeal decided, and put conditions for them to appear before the investigating officer. You know, all the people we are representing have families, and their families are here. They'll stand surety for them. There has not been any compelling reason by the state to deny these people their freedom. May the court get favor in our application with the support of the authorities and the annexures that we have given the court. And these are your people. They are now under you. They are wards of this court. They are no longer in the hands of the police. Thank you, Your Honor.
Thank you for granting us audience. I have been here since 8:40 a.m. I came under the mistaken belief that I would have done and left early, but such is the nature of the process of justice. May I first say this? This application is abusive in 3 ways. Actually 4 ways. 1, it's an abuse of court process. I will explain. 2, it's an abuse of the authority of this court. 3, it's an abuse of the rights of the suspects or the respondents in the application, more particularly the third respondent whom I represent. And the 4, and perhaps most importantly, it's an abuse of the Constitution of Kenya, which our courts, from the Supreme Court to the High Court, have variously held that the Constitution is not a piece of paper. It's not a decorative document. It must have meaning. Why do I say it's abusing of legal process? If you look at the prayers sought, sorry, before we go to the prayers, the intitulment or the title of the case, it makes no reference to ATPU or terrorism investigations or inquiries. And this court is gazetted as an anti-terrorism court. In fact, when you retire and read through the application, which is fairly thin, you will notice that the word terrorist has been used only once on the first page, on ground number 2, within the grounds of support of this application. Nowhere else is there reference about terrorism. 2, it is an abuse of court process because this court, respectfully, is not a gazetted anti-corruption court. So there is a question of jurisdiction. And when you have no jurisdiction, like I'm inviting you to find, like was held in the celebrated authority of Lillian S. by the late Justice Nyarangi of the Court of Appeal, when a court or tribunal finds it has no jurisdiction, it downs its tools forthwith. And I invite you to down your tools. Why do I say it is an abuse of the authority of this court? In the same application, there is ground number 3 in the ground of support of this application. There is a clear statement that on the 4th of December 2025, number 237018, Chief Inspector Gladys Mbula came to this court with various miscellaneous applications from number 626 to 644, seeking search warrants of the, I don't know what, because we have not seen those applications, but they obtained the orders they sought. Now, go back to the prayers. Other than asking for 10 days, the next important prayer is that the court makes an order authorizing the in-charge DCI ICT laboratory to forensically examine electronic gadgets recovered from the respondents. Meaning, in my humble understanding, that this is the order that Gladys Mbula sought, or may have sought, or ought to have sought in those miscellaneous applications from 626 to 644. If she may have omitted the prayer for this forensic examination, the remedy is not to come back with a new application. The remedy would lie in them making an amendment to that application and seeking a review of the orders so that they go back and do that laboratory examination. Remember that even the recovery or the detention of the electronic gadgets that they took from the respondents, they needed an order of the court to do so. If they didn't, it would be an abuse of the authority and the power of this court. This is not a walk-in, walk-out kiosk. This is a court of law that does justice. I implore the prosecution to recognize that they are princes of justice. They are priests of justice. They are not conveyor belts of desires of people who may want to harass individuals. The third abuse I mentioned is abuse of legal process in contravention of Article 157, sub-Article 11 of the Constitution. If you read through the application, the grounds, and the affidavit, there isn't one sentence that A links any of the respondents, more particularly if I speak for the third respondent, to any known crime. And this I'm saying without prejudice to my earlier submission about the lack of jurisdiction. And B, it is founded on suspicions. You will see the word suspicion, suspected. That suspected is used so many times I couldn't even count. Suspicion is not enough. We all suspect each other, even amongst these people standing here. I'm sure there are people who are suspecting others about something, I don't know what. So you can't say because we suspect, detain them. My learned colleague has said that crimes are, they might be connected to other crimes, which is also found in in one of the paragraphs of the grounds that they are likely to be connected with other crimes. Right now, as we speak here, someone is committing a crime somewhere in Kenya. Are you going to detain the whole country so that you stop crime? This suspicion and about potential crime being committed. That is the reason we have a standing authority called the National Police Service and the DCI as a permanent investigative authority. Oh, and related to the anti-corruption issue, that is why we have the EACC to investigate economic crimes, anti-corruption and economic crimes. Therefore, there is no ground that has been laid to demonstrate why they should get a detention order. In fact, they should apologize for having arrested these persons without reason. Why arrest if you have no evidence? If they had any evidence, they should have disclosed it in this application. None is disclosed. So you don't go to somebody's house, arrest the person, and then tell the court we suspect Mr. Ndubi to have done this, or we might be committing a crime. People commit crimes even in the privacy of their rooms. They should be going to Mulot to get those young boys who are stealing people's money through mobile banking. Then, something rather outrageous, which is both abusive of your authority and abusive of the defense or the respondents. They have stated that somebody amongst the respondents, one is working in Ganze, another one is working in Kariako, another two are working in Yao House, one is working in Kamkunji, and another one is in Sili. Now, but there is no linkage. There is nothing they have linked these people that whoever was in Ganze helped so and so who was in Kariako to get an ID or a passport. Then they are abusing us as Kenyans in terms of common sense. We know that to apply for an ID or a passport today, you go to a cyber cafe, you apply through e-citizen. You can print as many forms of from the e-citizen portal as you want. That doesn't make you a criminal. It doesn't make the printing of that form a crime. And none of these people who are here works for e-citizen. Further, from the application, you can see these are people who work for government in different departments. They have not connected the departments to say this is how they aided each other as the departments to either issue an ID. How does a man who was working for immigration help somebody to get an ID? Or somebody working in the NRB to help somebody to get a passport? When the passport, you go to the e-citizen portal from a cyber cafe even in committee here. My client, the third respondent, has worked for 18 years in the Department of Immigration. There is nowhere in this application, neither in the grounds of support nor in the affidavit in support, to show the period or periods within which these alleged offenses could have happened. This is what gives our judiciary a bad name. Because once you grant them the days they want, people are not going to look at the prosecutor. Mr. Kiage will walk the streets without people not seeing him. But you, they will look at you and say, there is that magistrate.
I hope senior is not trying to intimidate God on a light note, because now that me borders on. I really hope that was on a light note on his part.
Nobody can intimidate our court.
Oh, the only person who intimidates our court is the law. No one else. Not me, not you. I wanted to be very brief because this application discloses nothing. It discloses completely nothing. They are asking, whereas my colleague states the levels of employment of the various respondents, when he wrote to the third respondent, he says he works in the immigration. He didn't say that he's a cleric officer. Thankfully, it is in the application. When did you ever see a cleric officer signing a passport? Cleric officers can only carry a completed passport signed by an authorized officer and possibly take it to the collection point. That's all. I mean, it is laughable what they have brought. There are many things I would have said, but I don't want to waste the court's time, rather spend too much time making the very same point. But the last point I wanted to make in regard to this application is this thing called intelligence. And they have received intelligence of this information and that information. This was abused, particularly when some very well-known Kenyans whom I shall not name were prosecutors under the office of the Attorney General. They used to go out to court and say, we have intelligence. And the courts would not question what intelligence or what is the source of intelligence. Because of the violations of people's rights, Parliament saw it fit to enact the Witness Protection Act so that there would be some reasonable disclosure to a suspect or a person of interest without endangering the life or safety of the witness. So you can't say we received intelligence as if they have thrown away the Witness Protection Act through the window. They now come and say intelligence. Intelligence is what? Is it verified? I had the benefit, if I should say this without patting myself on the back, I had the benefit to participate in two important commissions of inquiry, the Akigumi Commission and the Waki Commission. That's when I learned that intelligence is classified and filtered. There is what they call raw intelligence, which has got gossip and rumors. By the time it is classified with a red file, that is reliable information. We don't know what they have. They have talked about an inventory which they have not produced. And actually it's not that they have not produced, they think about it as a prospective instrument for the future. But when they get to some inventory, so more offenses may be disclosed. I don't want to belabor that point that has been made. Last, the violation of the Constitution. The Constitution indeed, under Article 49, has granted the prosecution or the police, actually it's the police. I was surprised that this application is being made by the DPP rather than the police, but if you look at the CPC, it is the police who are supposed to have made the application. It gives them the right to approach court and say, we have compelling reasons. I took the trouble to look through the Black's Law Dictionary. What is a compelling reason? And without going through everything that I took down, a compelling reason is not defined in one word, but in a phrase. But it must be a reason that convinces court to depart from the usual standard of procedure. The reasons must be cogent, they must be convincing, they must be forceful and appealing to reason. Conjecture does not fall anywhere in this categorization. Guesswork doesn't fall anywhere in this categorization. It must be strong, convincing, and beyond reasonable control, often requiring a high standard of proof. What have they proven by just saying we suspect these people will have been committing this offense? They have here they have not even given the numbers of the passports, even if they were to give them in confidence or in camera to say these are the passports we suspect that these people facilitated, or the IDs we were facilitated, respondents so and so, respondents so and so. They have not said anything. So there is no cogency, there is nothing compelling. For which reason, Your Honor, I would like to implore this court to do one of the next three things. A, you strike out this application in its entirety, or if there is any doubt in respect of any of the suspects, may I emphasize in respect of the third respondent. He's a young man with a young family. His eldest son is, or child is 11 years. The youngest, he has two children, unlike 11. one is 11 years and the other one is 6. They haven't seen their father since Friday. Asking for another 10 days. And in the application they've said 10 working days, yet they were arrested on a weekend. Why they wanted working days from the court? And yet when they are working, they are busy on weekends and holidays. I do not understand. I think that is again further abuse of your authority. The second, you strike it out for want of jurisdiction. The second is that in the event you want to take time to reflect and make a ruling on this application, I implore you to admit the third respondent to reasonable bail terms. And on account that there is nothing they have said about the nature of evidence or investigation they are conducting, what they have done so far since arrest, you can take it that they have done nothing. If they have done nothing, they can't come to you to be aided. They have held them from others Friday, others Saturday, up to today, Monday. It is now they want the court's assistance. They must not be permitted to have their cake and eat it. The very final point, lawyers have this funny habit, and I'm guilty of it. I keep saying final. But I hope this is the final completely. That the particular section 36A of the CPC permits the court to grant a suspect or a respondent in this case into bail or bond terms with conditions. So the fear my colleague has about them going to interfere with people, how can a clerical officer interfere with the files in immigration? But you can order them not to go back to their offices for between now and the time you're issuing the ruling, if you don't issue it now, or such time as they will have finished the investigation and possibly cleared it. And I wish my colleague would have made the commitment or undertaking that in the event they don't find my client, the third respondent, responsible for any of these crimes they are alleging, that they would compensate him with damages that are reasonable and punitive. Thank you.
pursuant to your directions, Your Honor, we appear in both of them, me and Omari. So we will be doing our submissions now.
Both of them.
Yes, both of them. Bismillah. Your Honor, the application before you is opposed on behalf of the respondents for the following reasons, Your Honor. The application before you, Your Honor, is a demonstration of violation or an attempt to violate. It's actually a violation of the rights and liberties of the respondents before you. Your Honor, the application is brought in bad faith, and the entire procedure, Your Honor, process is intended to humiliate the respondents, as demonstrated by the application and the act of the investigators to display the photos of the respondents on their website and other social media platforms. Therefore, it's not brought in good faith, Your Honor. What we are being told in this application, Your Honor, is that they received intelligence information. Instead of acting on it and investigating, they decided to infringe on the rights and liberties of the respondents. By arresting them on Friday, so that they remain humiliated until Monday, when they present this application to extend the time of humiliation, Your Honor. Your Honor, in respect to this the applicant in the respondent, the fifth respondent in 646, that's Mr. Abdurrahman Robaguyo.
Sixth.
Is the sixth? Yeah, the sixth.
Yes.
It's indicated in the notice of motion and also reiterated in the supporting affidavit that he is an immigration officer working at Jomo Kenyatta International Airport. And then ridiculously, they are saying he's suspected of issuing irregularly passports at Nyayo House. What is this mockery or what's intended? He has not been arrested, Your Honor, with anything. Nothing was recovered on him other than his phone. Your Honor, what you are being invited to for allowing this application is demonstrated in the affidavit, supporting affidavit, and also in the notice of motion, things that the prosecution or the investigators can do without necessarily infringing on the rights of the respondents, such as identity parade, which as my colleagues submitted to earlier, is it called for? They are also talking about victims in issuance of passports and IDs I don't know whether there is a victim there. And therefore, Your Honor, I pray that this application should not be allowed. In addition to that, Your Honor, specifically for the sixth respondent in 646 is a sick man who has been diagnosed with asthma.